That was a mistake. So, guys, we're going to go ahead and get started. If you look at your afternoon agenda, Jani's going to share with you a little bit about the law, and then we're going to break into some small groups. But before we do that, this is the membership portion of the program. So for those of you who are not familiar with NACDL, we are the National Association of Criminal Defense Lawyers, and we are here for you. My name's Bonnie Hoffman. I'm the new Director for Public Defense Reform and Training. I've been on the job now 2 weeks. Prior to that, I spent the last 21 years as a state public defender in Virginia. So I want to talk to you for just a minute about the benefits of being a member of NACDL, because I was a member long before I was on the staff. And fundamentally, what I found is it's an opportunity to be connected with other people who do what you do and get it. A lot of times I think people look and think about NACDL as a white-collar bar, as a federal bar, as anything else. And I'm going to tell you, as a career public defender, it is a public defender bar. Public defense makes up a large part of the work that we do. It is an opportunity to do everything from, we do pretrial justice reform training like we're doing with you guys. We provide scholarship money to attend CLEs. We provide online resources. We really are here to serve you. So if you're interested in membership, please come over and see Diane or I. We offer a lot of introductory rates, and the goal is to provide you an opportunity to be connected to a bigger community. And for those of you who've been doing this, usually we come into this work because we have a passion not just for going to court and litigating cases, but because we want to do justice, because we want to see systems that are fair, because we want people to be treated like people. And one of the things that I think NACDL brings to the table is that advocacy work. We do amicus work in state courts. We do reports all over the country. We provide an opportunity for you to be connected to a bigger system. And that is everything from a daily briefing, which will send you into your inbox every morning, all of the criminal justice issues that have been raised, every news article, every print media, YouTube, everything. You're going to get a chance to be connected to those bigger issues. You're going to get a chance to be connected to other people, most importantly, who do what you do. And I keep coming back to that, but really for me, that's a big piece of this. You know, outside of your own office, it's really hard to connect to people who don't do this kind of work, who just don't get it sometimes when you talk about the issues and the things that are important to you. And this is like getting almost 10,000 instant friends who get what you get, who care about what you care about, and who do what you do. So with that, I'm going to encourage you to think about, if you're not a member, to become a member. If you were a member and you've let it lapse, come on back. We want you back. And with that, I'm going to turn things over to Jani.
All right, so anyone who's seen me speak in the past knows that I have a tradition of giving out constitutions for participation and different things. But I thought, well, I don't know if constitutions is what we need. We might need some 5-hour energy drinks. So we will be having some participatory gifts today. We've got some, fidget spinners in case you've got some time off, whatever we need. Because I like people who look like they're interested, even if you're faking it, it's okay. And the other thing I'd like to share is, first, no one's mentioned we have 6 new people here today, so I would like to personally and on behalf of everyone welcome Wade Bainham, Genesis Draper, Natalie Ware, Emma Cantu, Jen Gott, and Shirlene Cruz. So thank you all for taking the jobs. We're very excited to have you, and the other thing I'd like to say is Jackie Carpenter once said, if you have a question about bail, don't go to appellate. They don't know anything. And that could not be truer. Because my excuse is, before I came here, I only did capital. No, I wasn't worried about them getting out. I was just worried about them living, And so coming here in appeals, again, not so much worried about getting them out. So this presentation and my husband Ted Wood helped me immensely, with getting through this. It's a mile wide and about a ½ inch deep. But I am working on the manual. Ted Wood has done substantial portions. Alex is working on it, and hopefully by the time we're done, it'll be about 3 inches deep. So that's the goal. All right, bail. Really, what bail's all about is money, right? I mean, there's no question. I can read the listserv. I was commenting to someone, if you're on the Harris County Criminal Listserv, Carl Pruitt, who I don't know, put some comments on there yesterday, and I said to Alex, it's almost as if he wants it to fail. I was stunned. Like, how did that happen? Okay. I know, but you think he'd want the goodwill of people. No. Really? All right. It used to be Dixon Dawson, now our deans of criminal law are Dixon Schlemeski, and I love this. The use of a bail schedule is contrary to the entire process. I mean, if they're telling you that, that is true. And you know why I know that? Because even the CCA quotes them as authority. Like if they don't have a case, they'll quote Dixon Schlemeski. It's on your Westlaw. I've read about 500 pages that they had to say about bail. All right. Thought we'd step back, sort of where this somewhat began. Roth, Gary versus, as Chief Justice Roberts says in oral argument, Giuseppe County. I listened to it yesterday. I was like, oh, Giuseppe. Okay, so what marks the initiation of adversarial judicial proceedings? And this is what that sort of began. This person was arrested and put in jail and never given a lawyer. Ultimately bonded out, then they indicted him and arrested him again. And he ended up suing because he hadn't been given the chance to know he had the opportunity to bail out, he hadn't had all sorts of opportunities. So, magistration, which is a made-up word, okay, it really is, marks the initiation of adversary judicial proceedings with the consequent state obligation to appoint counsel within a reasonable time. All right, that's a U.S. Supreme Court case. I have some lifesavers. Who can tell me it was an 8-1 decision? Who do you think the one was? Oh, who said that first? It came from somewhere over here. You need a lifesaver. Yes, he does grant stays. But I was like, But to listen to the oral argument, and I don't recommend you all do it because you all have lives and you're all interesting people, unlike me. It's fascinating the discussion that they had, like why it wasn't a big deal, where Scalia is like, well, it's a big deal. But Alito and our good friend Chief Justice Roberts were like, oh, it doesn't bother me. But they went along with it because of precedent. All right. So the initial appearance, when you learn the charge against him, and your liberty is subject to restriction. So question, does there have to be formal charges? Who said no? Oh, Lori Gooch said no. Could you pass that back to my good pal, Lori Gooch? Okay, so it's not driven by the prosecutor, is the point. Okay? Does the right to a counsel attach? A lot of times I have my little thing up here. Does the right to counsel attach at the Article 1517 hearing, even if the prosecutor is not aware? Yeah. Is an indictment necessary? No. Oh, somebody wants a prize. I just heard someone. Danny. This. All right. I'm over here. Okay, this is basically a defendant case flow from arrest to magistration. I'll email you all this, but what happens is up here, the magistration, this is where a probable cause and bail are set. So there's a lot of things going on before we even see the person. Okay, bail's the security given by the accused that he will appear and answer before the proper court, and includes a bail bond or a personal bond. Okay, I have a very serious question about this. Is it a personal recognizance bond? Do we have those in Texas? No. Who said no? You get the fidget spinner of all fidget spinners. You pass this back. If they were cheaper, I'd have more. I was like, oh, those are expensive fidget spinners. We don't have a personal recognizance bond. We use that term. We do not have that. And you know who told me that? Ted Wood. He did not get a fidget spinner. I'm going to. The next screen. So, we have a personal bond, but it's unsecured. So the judge will say, I set your bond at $500, but you don't have to pay it. So it's not on your own recognizance. There is a monetary amount, which I did not know till my inch deep of studying came to be. Then there's bail bond, which is cash or surety. And here is where the money comes in. This is the oath that they sign for the personal bond, where they say, pay to the court the principal sum of amount, plus all necessary and reasonable expenses. So they are given a bond amount, but they don't have to pay it. So it's not on their own recognizance, which I should give myself a prize for learning that. I'm kidding. I can keep all of this till the end of the day. All right. So we all know we have release for Class C fine-only offenses. Does anyone know what that little insignia is at the bottom? Catch and release. That's the official catch and release. Who needs a 5-hour energy drink? Oh, Angela. I don't know if these are bad for you, so I take no responsibility whatsoever. It's a comment on, like, it's probably full of crap, like Diet Coke that I drink. All right. The Constitution, the 8th Amendment, that just says excessive bail shall not be required. That's all it says, really. It's not like you get to go free. They're just not going to charge you a whole bunch. Does the Court of Criminal Appeals care if you can make your bail amount? No, they do not. And I say that with all the love in my heart. All right. I know. Anna's like, I don't believe it. But how many of you have read the Texas Constitution? Yeah, some of you. And I'm not plugging TCDLA, but if you belong to TCDLA and you get their phone app, it's got all that on there. So when just before I came up here, I was like, oh, what's 11A say again? I got to be ready for all these hard questions, which no one is going to ask me. Thank you. Thank you. All right. That's right. Come down the hall and I'll look it up. So we have, and these Article 11A, these were all added in later. You will not believe all the stuff in our Texas Constitution. Like there's all these victims' rights things that they've added in to be PC. And no, I'm not for PC unless probable cause is not found. I'm kidding. All right. So limitations on pretrial release. And I am off my pages. I'm going to go here. Okay, 11A. These are limitations. Habitual offender, can they be released? Yes. It's discretionary. Who can't be released? That's it. That's it. So pretty much anyone else can be released. So non-capital felony while on bail, all of this. All right. The magistrate cannot deny bail on 11A in the Constitution. If you read the Constitution, only the district judge can. And we're going to talk later about all this weird rulemaking authority and how Harris County has all these rules. I'm going to step out of my bail talk. Whenever you see these rulemaking authority, like rules, we're going to see Harris County rules, I want you to think, what gives them the authority to do that? Do they have the authority? Is it something we want to ever challenge? Look, you can't just like make a rule that's substantive and, you know, that affects constitutional rights. So I just always want you to think about that. Whenever you see some rule, especially like I do it in rules of appellate procedure, what gives them authority to do that? And do they have authority? And if you don't like it, that's what we're for, appellate. We'll challenge it all day or night. I guess 24/7 according to the new schedule. All right. So now 11B, the judge or the magistrate. So those are accused of a felony involving family violence, which here's the other thing I learned about bail. Man, family violence is complicated. Super complicated. There are so many conditions and rules. The statutes for family violence are literally like 5 pages single space. They really don't like that. Because if the legislator wants to be reelected, like, that's a good cause. All right, Article 111C. These have to do with emergency protection orders. Judge or magistrate can deny bail. All right, here we go. Only the court before whom the case is pending may release on personal bond. This is the statute. This is the Code of Criminal Procedure, which our representatives and our senators have voted on, right? Well, they also voted on to give Harris County special rules, which I didn't know till I started this. Did you all know this? They're on the website, justtext.net. Ted Wood found them for me and then emailed them because I was like, I don't know where those rules are. And there they were. So they have all sorts of special rules. All right. So this is what we would term a general statute. You know, generally may release on personal bond, except capital murder. I'm not sure. All right. I'm behind myself, now I'm ahead of myself. Oh, here's our special rule. The government code gives Harris County permission to make its own rules. Right. So just think about that. The government code is Harris County, and they don't name it Harris County. Like, we're not going to give Harris County special permission. We're going to give it to a county over 3.3 million. Oh, who falls into that? Us. All right. So that's why a magistrate can admit to bail those serious offenses when typically only a district judge can, because they've been given rule. The legislature gave the government code, gave them special rules. I'm not 100% sure. Is this on tape? I'll just move on. I'm kidding. I don't know. All right. Burden of proof. There has to be a substantial showing of guilt for these bail. All right. Ex parte more. It's a great case. I recommend you read it. It's written